et al., Rushbond PLC and JS Design Partnership.
Good morning.
Good morning. I appear for the appellant with Mr. Brown, and Ms. Sinclair, Queen's Counsel, and Mr. Shirazi appear for the respondent. You'll have seen that this is an appeal against the judge's striking out and summary dismissal of my client's £6 million property damage claim. The issue the judge had to decide was whether or not my client's case that it was owed a duty of care by the defendant in respect of damage caused by a third party was fanciful, such that its claim was bound to fail. And the judge said it was fanciful and bound to fail for two reasons. First, she held that this is a pure omissions case, and secondly, she held that the case didn't fall into any of the exceptions to the general rule that there's no liability and negligence for pure omissions. And on this appeal, we say that she was wrong about both of those points. It's sufficient for my purposes to say that she was wrong about either of them. If it's not a pure omissions case, it's irrelevant whether or not an exception applies. And if an exception applies, it doesn't matter if it's a pure omissions case. So what I wanted to do, by way of my submissions, is firstly to make some introductory remarks, then to go through the facts, then look at the law relating to omissions, and then look at the law relating to exceptions. That's convenient. So if I start with my introductory remarks.
I should have said, Mr. Elkington, before you go any further, I assume that you and Ms. Sinclair have divvied up the time between you, and you're certain that you will be finished within the day.
Yes. We haven't expressly spoken about it, but I will be finished, I hope, comfortably before lunchtime, leaving myself a little bit of time for reply.
Okay.
You will, speaking for myself, you will need to, because I have that vital thing, my booster jab, pretty much immediately after court. So I would be grateful if
that's helpful. Thank you.
You kept it.
So, introductory remarks. This case involves a situation where a defendant was on in the claimant's building with permission, but without there being a contract in place between them. And that's not an uncommon situation to find. It arises in the commercial context, and we can think of some examples. If a contractor visits a property to prepare a quote for the provision of services like cleaning services or the installation of IT, or if a builder visits a property in order to prepare a tender for building work, or a professional like an architect or a QS visits a property to assist a contractor preparing a tender or quote. In all those cases, someone will be on someone else's property with their permission, but without a contract. And one can think of examples in the domestic context as well. Again, someone visiting to prepare a quote for works, or an estate agent who goes to a property to prepare a market appraisal so the owner can decide whether or not to place the property on the market, or the potential buyers of a house who want to view the property on their own, or a neighbour's gardener who's permitted to enter a property to get access to trim the neighbour's hedge because he needs to get that side, or a neighbour's builder who needs to get access to do repairs to guttering on the boundary wall. And again, in all those situations, one person will be on another's property without there being any contract between them. And in those examples, the property owner may be at the property at the time, or as in this case, may not be on the property, may hand the keys to the property and the details of any alarm over to that party. And in a situation like that, being permitted to enter a property, it creates proximity and a special relationship between the building owner and the visitor.
Why do you need a special relationship?
Sorry,
Why do you need a special relationship?
I'm not saying I need one. I'm just saying it does create one. It creates proximity, and I'll stick with proximity if I don't need to go further, between the building owner and the visitor. And for that reason, for example, an occupier of a building owes a duty of care to its visitors. So visitors could bring a claim against the building owner. And so far as a claim by the building owner against a visitor is concerned, there's no doubt that if any of those categories of people that we've just identified were negligently to cause damage to the claimant's property, then they would be liable to the property owner. example, if they started a fire by negligently discarding a cigarette, the property owner would have a claim against them. If they left a tap on negligently and flooded the property, again, the property owner would have a claim against them. So the question is whether or not a claim by the building owner against the visitor is hopeless, where the damage isn't caused directly by the visitor, but is instead caused by a third party who's allowed to enter into the property by reason of the visitor's conduct. And the argument that no such duty is owed because the visitor's conduct amounts to an omission is striking. Looking at all those categories I identified, if any of those categories of visitors entered the property, disabled the alarm, and left the front door unlocked while they were there, it said they've got no liability because they had permission to unlock the door, open it and unset the alarm, and so the failure to lock the door was a mere omission. And by the same logic, if they left the front door unlocked and wide open while they were there, it said they could have no liability because, again, they had permission to open the door and the failure to shut the door was a mere omission. And again, by the same logic, if when they left the building, left it wide open while they're there, and they leave when they've finished, having done their survey or whatever it is they're on there, done, they've chopped the neighbour's hedge, and they leave the front door wide open with the alarm disabled, it said they had no liability because it's a pure omission. So even if they leave the front door open or the side gate open with the alarm off for days or weeks, however foreseeable it is that someone may come in and steal something or do some damage, they've got no liability because it's a mere omission. That's the effect of the judge's conclusion that this claim is hopeless. And that, in our submission, is remarkable and at the very least arguably wrong. And of course, I only need to show that it's arguable that a duty was owed in this case, because it's a summary judgment application and a strikeout. If there is a duty, of course, whether or not the visitor's conduct amounts to a breach of that duty, whether or not it was negligence, will be an issue, and whether or not any breach caused the loss will be an issue. But at the very first stage of the analysis, is there a duty owed by the visitor to the owner of the building in respect of the damage to the building, even where that damage is caused by a third party? There is in our submission at least a real prospect of success of showing that such a duty is owed. You'll have seen from the respondents' written submissions that they repeatedly characterise the claimant's complaint as being that Mr. Jeffrey failed to lock his party inside the building. That, of course, isn't the complaint. The purpose of a door lock is to keep intruders out of the building, not to lock people in the building. The claimant's complaint is that the defendant didn't lock intruders out of the building, with the entirely foreseeable result that an intruder entered the building and subsequently the fire was started. So those were the introductory remarks that I wanted to make. Could I then come to the key facts? And as you know, the court's proceeding on the basis that the facts alleged by the claimant are true. The judge summarised the facts in paragraphs 3 to 6 of her judgment, but that was a short summary, and in our submission didn't tell the full story. So I just wanted to run through the full story just to give the factual setting for the legal submissions that will follow. And can I start with the building and invite you to take out the appeal bundle and turn to tab 4 on page 52. There we have a picture of the building. It's a large building in Leeds city centre, formerly the Majestic Cinema. And the facts I'm going to go through are all set out in the pleadings, and I won't take you through each of the pleadings unless you any particular references you want me to identify. The claimant had had substantial works carried out to the property so that it was in a shell condition suitable for fitting out by a tenant for leisure use. And the claimant had identified and evaluated the risk of fire at the property, and it had taken steps to protect the property against the risk of fire, and it had done that by means of physical security of doors and windows, the use of an intruder alarm and monitoring, and regular property inspections. And the purpose
Was that
of those-
necessarily in relation to the risk of fire as much as general risk about being broken into and occupied and otherwise vandalised? It doesn't have to be fire, does it?
No, it doesn't. I mean, the pleading especially identifies that the claimant had identified and evaluated the risk of fire, but yes, and fire is probably the most serious risk that an unoccupied property like this faces. But of course, my lady's quite right that there would be other risks of vandalism, flooding, taps left on,
Yeah.
so on. And all of those are catered for and protected against by the steps that the claimant had taken with door locks, alarm, and so on. And the building was unoccupied, and it was in a city centre location where it was attractive to vagrants. And it was vulnerable to surreptitious entry and use by intruders in the event that its alarm was deactivated and its access door was unlocked. And there was a risk that an intruder would willfully or accidentally start a fire within the building, causing damage to the building. And the risk of such intrusion and damage was reasonably foreseeable. So the property was at risk of damage by an intruder, and it was protected from that risk by the locks on the doors and the alarm.
Do we see in the photograph the door in question?
Lord, not in the photograph. Yes, it's the third one along on the right, if I can put it that way. I've got a bit of. There's the first door, then there's a one-way sign behind which is the second door, and the door in question is the third door. But I can take you to the.
So the one beyond the one-way sign.
Well, it's the second one beyond the one-way sign.
Oh, the second.
It's the third door along.
In my copy, it looks as though someone's written an X at the foot of the door.
Yes, I can. I've got two X's on mine, which doesn't. But it's
Anyway, it's the
Yes,
third one along.
Yes.
Down that road. So the second one along from the one-way.
Yes.
Yeah.
And I can take you to the plans, which I was proposing to do anyway, which are at page 80 of the bundle.
We're within about 200 metres of the station, aren't we?
I confess I've got to bow to your lordship's knowledge of central Leeds.
So,
Come on, Mr. Elkin. I think we're within
We're certainly
about
very
200 metres.
close to the
There's
station.
a lot of nodding going on behind you.
It's very close to the station and the hotel where you come out of the station.
Yeah.
One of the drawbacks of lockdown is I haven't been to Coulson Leeds as frequently as I would have liked to have done. There we are. So the plans are at page 80 behind tab 5 of the bundle. And what we have here is half a dozen plans which start at the bottom of the building and work their way upwards. So page 80 is the basement, and you see the rounded front of the building towards the top of the page. 81 is the basement mezzanine. 82 is the ground floor, and I'll take you in a moment to another plan of this which shows where the intruder, where Mr. Jeffrey entered and where we say the intruder entered. That's the ground floor, and that's where there was used to be seating for over 2,000 people in a cinema. Page 83 is the first floor. Page 84 is the first floor mezzanine. And page 85 is the second floor. And then we get up to the roof on page 86. So a very large, complex building, lots of staircases, lots of rooms, and so on. Suffice to say, if you were to play hide and seek or sardines in there, the game would last a long time. And then the last plan to take you to is at page 45. This is another plan of the ground floor, the same as we just looked at, albeit rotated by 90 degrees. And so the top of the page is Quebec Street, which is where we just looked at the photos of the doors. And you may see the third door along, something marked entry door used by JSD, JSD being the defendant's JS design. So that's where Mr. Jeffrey came in, and you'll see just below that there's a red letter K, which refers to K as the keypad. That's where the intruder alarm control panel was. And then there were various numbers showing where there were PIRs. Those are the passive infrared sensors for the intruder alarm, which cover much of the building, but by no means all of it, because it would have to be so many to cover the whole of such a large, complicated building. And a feature of that door that he came through is that inside it there was what's called a snib turn, which, if you don't know, is like a bathroom lock. So you just twist it. You don't need a key. You just twist it, and it locks the door. And that both keeps the door shut, stops it swinging open, and it stops anyone being able to get inside.
So you don't need a key. You need a key to get in, but you lock it just by turning the lock.
Correct. And therefore, if you needed to get out in a hurry, you wouldn't need to fumble with keys. You just turn the lock. So that's the building. Turning then to the parties, the claimant was the owner of the property, and it was trying to find a tenant for the property after having carried out the works which I've just described. And it had appointed marketing agents called Pudley Shuttleworth. They were marketing agents rather than managing agents. And those marketing agents had keys to the property and the code to the alarm system. A company called Burning Night Limited was considering taking a tenancy of the property, and negotiations between the claimant and Burning Night Limited were at a well-advanced stage. And Burning Night had instructed the defendant firm of architects to advise it on the condition and the potential of the property. And one of the defendant's partners was Mr. Jeffrey. We then come to previous visits before the visit in question. Prior to the visit in question, Mr. Jeffrey had visited the property on a number of occasions, together with a representative of the marketing agents, Pudley Shuttleworth. And as a result of those visits, Mr. Jeffrey was familiar with the layout of the property and the door locks and the alarm system at the property.
Do you say that any of that matters? Whether he'd been there before, whether he was familiar, does it matter?
I would say no, but insofar as it's relevant to the extent to which there was a relationship, proximity between the parties, it might be said to be a factor in that.
Okay.
And on those previous visits, what the Pudley Shuttleworth representative had done was to lock what's called the access door, this door onto Quebec Street, before moving out of sight of the door into the middle of the building, into the building.
Is that pleaded?
It is. That's in paragraph 8 and in reply paragraph 12.
Thank you.
And on one or two occasions, while the Pudley Shuttleworth representative had gone to the building with the defendant, and opened the building, they had then left the defendant there. And on those occasions, the Pudley Shuttleworth representative had either locked the door themselves or had asked the defendant's representative to lock the door. That's again reply paragraph 12. So that's the context for the further visit on the 30th of September. We now come to the visit on the 30th of September. Mr. Jeffrey wanted to visit the property another time, this time with a structural engineer and a quantity surveyor. So he contacted Pudley Shuttleworth, but no one from Pudley Shuttleworth was available to either open up the property or accompany him on the visit, and he was told that. But Mr. Jeffrey still wanted to go ahead with the visit, and Pudley Shuttleworth agreed that he could make an unaccompanied visit. And to allow him to make that visit, Mr. Jeffrey was provided with the key to the access door, the Quebec Street door, together with the code to the intruder alarm for the building. So he was on claimant's property at his own request, rather than at the request of the claimant. But the claimant was aware of Mr. Jeffrey's intended unaccompanied visit, having been notified by Pudley Shuttleworth. And the claimant assumed that Mr. Jeffrey would take reasonable precautions for the security of the property, and it relied upon him to do so. We say it reasonably relied upon him to do so. That's in paragraph 31 of the reply. So Mr. Jeffrey duly attended the property.
The reasonableness goes hand in hand with the assertion that failing to do it is negligent. The reasonableness of reliance, because as you said, it's assumption, nothing actually said. You've pleaded, I think, reasonable reliance.
Yes.
And that would follow or go with the allegation, which is not determinative at this stage, that it was negligent not to lock up.
Yes. Yeah. Our submission is that reliance, reasonableness or otherwise, is not a necessary ingredient for there to be a duty of care in a property damage case such as this.
But if it were,
that
would be the rationale.
Yes, and one of the features of the judge's judgment we'll come to is she said there can be no duty because there was no reliance when reliance has been pleaded. So Mr. Jeffrey went to the property with the two individuals, the structural engineer and the QS. When he arrived, the property was secured by locks and the intruder alarm was set, therefore keeping the property protected from the foreseeable risk of intruders going into it. He unlocked the door and he deactivated the alarm. And he then went into the building. But unlike Pudley Shuttleworth's representatives, when he proceeded to go into the building and go round it, he didn't make sure that the access door was locked. He didn't operate the snib turn. And that meant while he was inside the property, out of the view of the door, the building was unprotected. The door was unlocked and the alarm was deactivated. And moreover, since the door was unlocked, it was unlikely to stay shut. That's pleaded in paragraphs 21 and 22 of the reply. So the property was less secure and safe.
So it was unlikely to stay shut because of the nature of the door?
Yes, well, it's not pleaded why, but that's the assertion. But
well, it would be. With a snib lock, typically you would actually physically have to do it to engage. So unless there's a separate handle, which by implication from what you said there probably wasn't, then that would be the thing that would hold the door if it had been unlocked.
Yes. So the property was less secure and safe than it had been immediately prior to Mr. Jeffrey's arrival. And as a result of his actions, there was now a risk that an intruder would enter and start a fire. There was now a danger of the property being damaged by fire that hadn't previously existed. Now, Mr. Jeffrey spent about an hour in the building. He spent time in the basement, in the first floor, the second floor, and the auditorium. So he wasn't close to the access door, and he was unable to see anyone entering the building through that door. And there was no one tasked with keeping a watch on that door. So throughout the time he was there, the building was insecure.
That's in the very nature of the building, isn't it? So it's not a question of did he stray from close to the door. It's inevitable, given the size and nature of the building, that if you leave it unlocked, it is at some risk.
Yes. This is not a studio flat where you can sit there and see someone come in.
Exactly.
It's
So
like going to the far end of your garden,
it's
leaving
inevitable.
the front door open, or you're in something of a rabbit warren of a building. And that's why the Pudley Shuttleworth people had the practice of keeping the door locked. And as you know, the claimant's case is that during that period, an intruder gained access to the property, and subsequently a fire was started, either accidentally or intentionally, which caused extensive damage to the property. And it's for that damage that we bring a claim for over £6 million. Could I take you to 3 passages in the defence which are significant? The defence is in the core bundle behind tab 5. And the first passage is on page 63. And it's at the top of the page, subparagraph 3.7a, where the defendant says, as an empty property, the property was at risk of entry and damage by intruders to the extent that such entry was not deterred by locked doors and the alarm system. In paragraph 3.8, further down the page, the risk admitted at paragraph 3.7a, which we just looked at, was generally foreseeable, and so was foreseeable by Mr. Jeffrey. And then the last passage is paragraph 6.2 on page 69. It's 6.2 little 3. So it's a little 3 in the centre of the page on page 69. It was reasonably foreseeable that the risk of harm, the has been left out, it was reasonably foreseeable that the risk of harm to the property by an unknown third party was marginally increased for 1 hour on the morning of 30th September 2014. It goes to make the point that reasonable foreseeability for harm is inadequate to give rise to a duty of care of common law.
Well, Miss Sinclair will explain her syntax in due course, but I'm not quite sure what marginally means there, because certainly so far as we're concerned, on the facts pleaded, there was no real risk while the building was secure.
Yes.
Therefore, the risk arose because it was rendered unsecure for that week.
Yes.
That hour. I'm not quite sure what's marginal about that, but
It may be
if it matters, Ms. Sinclair will explain it.
Oh, yes, maybe it was the extent of time, one doesn't know. But it doesn't matter if it was marginal or massive. If there's an increase in risk, there's an increase in risk. And that increase in risk is caused by the defendant.
That's right, because the dispute in this case is not about the measure of response to the risk that should have been undertaken.
Correct. So that's all I propose to say about the facts, unless there are any other points that it would be helpful for me to clarify. So I wanted to come to the
But perhaps, do I understand that actually it's believed that the third party didn't enter through the snibbed or unsnibbed door at all? And does that matter one way or another?
Well, there's uncertainty about that. There's uncertainty about who it was that actually started the fire. Was it whoever went into the building through that unlocked door, or someone who got access to the building when that person came out leaving a door open, which allowed someone else to come in? And Mr. Jefferson was accepted he was in the property, and he was prosecuted for arson, but in fact found not guilty by the jury. So there's uncertainty about that. What there's not uncertainty about is that prior to Mr. Jeffrey's visit the building was secure, but it was rendered insecure. After he left, he locked all the doors, so again, it's secure again, and he set the alarm. But somehow, someone got in and started a fire, intentionally or accidentally, and the defendant doesn't suggest it was through any other route other than someone getting in during that period of the property being vulnerable.
So it doesn't matter. Thank you.
So that's a fact, and then I come on to, if I might, the law relating to omissions, and our submission that the judge was wrong to treat this as a case of pure omissions. And at the same time, it's convenient to deal with the creation of danger exception, because the two, as we'll see, are fairly interlinked propositions. And can I start with a very high-level authority, as it were, in the terms of Clark and Lindsell, so we can see where this all sits in the scheme of this area of negligence. And that's in the second authorities bundle at the back, tab 18. And the section I wanted to take you to, please, is at page 649, paragraph 7-51.
Sorry.
Page 649 of the bundle.
Oh, sorry. Page 649 of the bundle.
And it's section 7-51.
Thank you.
And might I invite the court to read that page? I'm sure you don't want to hear me read it out to you.
Thank you. There are a number of points I wanted to draw out of that. The first is that the distinction, when we're looking at the distinction between acts and omissions, is better regarded as a distinction between making things worse on the one hand or making things better on the other. And that's something that's developed in the Begum case that Lord Justice Coulson knows well and will come to in due course. The second point is that, as you see at 7-52, the principle only applies to pure omissions. The person who creates a danger, however blamelessly, may come under a consequential duty to take precautions to prevent injury resulting. And you'll see there's a footnote 213. That footnote refers to the decision of the judge in this case. Footnotes at page 651. And having summarised the case, the editors of Clark and Lindsell say this seems, with respect, somewhat generous to the defendant.
I was tempted to ask whether the editors of Jackson and Powell have yet commented on this case.
We'll have to wait for the next edition.
Between you. But I don't think, so far as I can tell, you haven't.
Not. I don't think so.
Could you just help me? I see that this is obviously the electronic version, so it's the consolidated main work incorporating the first supplement.
Yes.
What's the date of the first supplement? don't worry about it now. The only reason that it makes a difference is that I seem to remember, it may have been in Begum, being taken to Clark and Linsell,
Yes.
and thinking that it perhaps wasn't as up to date as it might have been, and I might even have said that in the
You did.
judgment.
You said there was no reference to the 4 Supreme Court decisions,
Well,
which you then reviewed in that case.
Even if I had noticed that, then it seemed to me worth drawing to their attention. So I just wondered if the first supplement is after Mrs. Justice O'Farrell's decision, it may not be after Begum. So,
Yes, it makes no reference to Begum.
fine, all right. Well, I'd just be interested in the date, but it doesn't matter for the moment.
Mr. Brown will
Yes, thank you.
find that out for me. So only the principle only applies to pure omissions, and so if there's a creation of danger, it's not a pure omission, and that's where I say there's an overlap with the rule we'll come to in a minute, that one of the exceptions to the rule that there's no liability for the conduct of a third party is where the defendant has created a danger which has been exploited by that third party. And then, if I could just emphasise in paragraph 7.52, the section starting 8 lines down, in such cases. Because in such cases, the omission is not considered in isolation, but as part of the activity as a whole. It's simply the element which makes the activity negligent. The whole activity amounts to misfeasance. The pure omission principle applies only where the failure to act can be viewed in isolation from other aspects of the defendant's activity and classed as non-feasance. And as we'll see in our submission, that's where the judge went wrong. She should have treated the activity as Mr. Jeffrey's visit to the property. One part of which was the fact that having turned off the alarm and unlocked the door, he then went into the building without locking the door, without arranging for it to be monitored. But what you can't do is you just pick out that particular criticism of his conduct and say, well, that's an omission, therefore there's no liability. We ignore everything else he did before that and after that. We ignore the fact that he disabled the alarms. We ignore the fact that he went into the building while the door was unlocked. Just focus on the fact that he unlocked the door. That's an omission. Or, sorry, that he didn't lock the door. That's the omission.
And maybe you would say it's a matter of semantics. One can say one failed to do something and categorise it as an omission, whereas if you look at the conduct as a whole, you say the conduct is rendering the building unsafe. It just depends how you label it.
Yes, and as we'll see, that's why the cases have moved away from saying acts and omissions. And the classic example that's given is if a driver hits someone at 50 miles per hour, is that an omission because they didn't brake, or is it an act because they drove into them at too high speed? It was an omission because they weren't looking out. It's two sides of the same coin. It is semantics, and that's why one moves away from the phraseology of acts and omissions and looks at the rationale underneath it and identifies that what you're looking at is whether or not someone's made something worse or failed to make something better. And I said I would, just while we're looking at Clark and Linsell, can I invite you to look at paragraph 7-60 on page 657.
Just give me that reference again, please.
It's page 657, and it's section 7-60.
Thank you.
Which is headed specific responsibility for protection from third parties. And I can just take you to the 4 situations identified by Lord Gough in Smith and Littlewoods, which are marked A to D. And we rely on 2 of them. If I can start with C, rather counterintuitively, where the defendant is responsible for a state of danger which may be exploited by a third party. And that I'm going to deal with at the same time as dealing with whether or not this is properly an omissions case, because of that overlap I referred to. And then letter A is where there's a special relationship between the defendant and claimant based on an assumption of responsibility by the defendant. And that I'll deal with separately, and that stands the entrapment situation, where someone comes onto someone else's property. Now, what I'd like to do is go through some authorities which set out the rationale for the rule, drawing a distinction between acts and omissions, because that obviously informs how the rule should apply in this case, and then some of the cases where the Supreme Court, Lord Reed in particular, has summarised the rule, because, and some of them are fairly general comments, and they of course apply in a whole range of different situations, and so I'll identify those which in our submission are most apposite for this particular factual scenario. So in terms of the rationale behind the rule, that's most clearly set out in Lord Hoffman's speech in Stovin, which is in the Authorities Bundle 1, at tab 5. Stovin and Wise is the claim where a motorcyclist brought a claim against the highway authority. He'd been hit by a car at a dangerous junction, and he sued the highway authority, and his complaint was that they hadn't done works to the road layout to a bank to avoid the risk of accidents such as his. And I can take you to page 943G in the speech of Lord Hoffman, please, which is on page 94 of the bundle. That's 943G on page 94. Just after referring to the Dorset yacht case, he says there are sound reasons why omissions require different treatment from positive conduct. It's one thing for the law to say that a person who undertakes some activity shall take reasonable care not to cause damage to others. It's another thing for the law to require that a person who's doing nothing in particular shall take steps to prevent another from suffering harm from the acts of third parties, like Mrs. Wise, she was the car driver, or natural causes. One could put the matter in political, moral, or economic terms. And then he goes on to go through those. In political terms, it's less of an invasion of an individual's freedom for the law to require him to consider the safety of others in his actions than to impose upon him a duty to rescue or protect. And I don't think I need to go through the moral and economic justifications that he refers to. And then the other passage I wanted to take you to, please, was page 945. Midway between letters C and D, 5 lines down in that paragraph, where he says, but this does not mean that the distinction between acts and omissions is meaningless or illogical. One must have regard to the purpose of the distinction as it's used in the law of negligence, which is to distinguish between regulating the way in which an activity may be conducted and imposing a duty to act upon a person who's not carrying on any relevant activity. So one can illustrate that difference on the facts of this case in this way. Say a passerby had walked down Quebec Street and saw that the door had swung open and was unmonitored. That we entirely accept that person would be under no duty to shut the door or to ring up the marketing agents or the owner of the building and say, your door's been left open, the building's vulnerable. Because that person was a passerby, not engaged in any relevant activity. They would also be under no duty if they saw a vagrant or anyone else enter the building. Even if they saw that person carrying a lighted match or a petrol bomb or a can of petrol. No duty on that person to do anything. Might be a moral duty, but rather like the Good Samaritan, no legal duty to go and help the person on the other side of the road. No duty to ring up the claimant. And that's because the passerby doesn't make any situation worse, and it's got no duty to confer a benefit on the building owner by taking steps to prevent the damage or tip the building owner off about the third party who might be doing damage to the building. That person is in an entirely different position to Mr. Jeffrey, who was carrying out a relevant activity, namely an inspection of the claimant's property. He arrived at a secure building, he disabled its security, and then he disappeared into the building, leaving it unsecure and vulnerable to entry and damage in a way which was entirely foreseeable. So Mr. Jeffrey converted the claimant's property from a secure building to an insecure building, and he created a situation in which the property was left unarmed, unlocked for an hour with no watch over the door. So he created a danger that the building might be damaged.
And I suppose it goes this far, doesn't it, that if he had left one of his assistants on the door, and the assistant had resolutely stayed on the door, the proper analysis would be he hadn't rendered the building insecure and vulnerable.
Correct.
Full stop.
Yes. Security would have been different, but it wouldn't. He wouldn't have made the position worse. He would not have rendered the building vulnerable to damage by a third party, which is what he did do. He rendered it vulnerable to damage by a third party, and that's why he was under a duty to protect it from damage by a third party. He has a liability, at least arguably, in the event that there was damage to the building by a third party.
But this appeal is not about liability for the acts of third parties, is it? This is about whether what he did was a pure omission, because that's the basis on which the judge found against you.
Yes, and well, she also found that she found it was a pure omission, and she also found that no exception applied. It's not one of the situations where there was a liability for the conduct of a third party.
Okay.
Sorry, say that again. She found that on the second element, I only ask you to say this again because one of the frustrating things about the authorities is that they often come under the heading of pure omissions. But actually what they're dealing with is liability for third parties.
Yes.
And just like Lord Hoffman weaves in a reference to third parties when he's actually, with respect to him, making a different point, it's not a recipe for clarity. So you say, my Lord put to you that this wasn't an appeal about liability for third parties, and you said it correct in the sense that it was dealing with the question of pure omissions, and then you said something about the exception. Mrs. Justice found that this didn't fit within the creation of danger exception.
Yes, and she also found that it did not fall within the exception that arises where there is a particular relationship between the parties which gives rise to the imposition or assumption of responsibility
And
for
that
the
would
conduct
be,
of a third
in
party.
this case, an assumption of responsibility for third parties.
Yes.
Yeah, I understand.
And that's your A and C that you referred
Yes, it
to
is.
at paragraph
Yes.
760.
Perhaps unhelpfully C and A.
Yes.
But by my Lord,
Yeah.
if I may respectfully say so, entirely right. The thing with omissions is sometimes there's no third party at all. If I watch a blind man walk off a cliff, there's no third party involved, but that's an omission, and I have no liability, however reprehensible that may be if I don't say, stop, look out. If I see a blind man standing at the cliff and someone coming up to push him, there's an involvement of a third party. But again, I've got no liability for that.
Yeah.
But the exceptions where there may be liability bite both where there's just in that subset where the omission includes the involvement of a third party.
Yeah, I understand that. It's just that, I mean, a number of the increasingly, liability for third parties is the area of contention in this field of law. And there are times when that in some of the authorities that comes in a bit by a side wind.
Yes, I certainly wouldn't disagree.
But I understand what you said, yeah.
So, looking at the difference between acts and omissions and identifying that what happened here was that Mr. Jeffrey created a danger, an insecure, vulnerable building, and that danger was exploited by the person who entered the property. And finding that there's liability in that situation, when one looks at the rationale of the emissions rule, we're not saying there was a liability on a passerby to raise the alarm. We're saying there is a liability on the person who's engaged in the relevant activity, inspecting the building, going on the claimant's property, and having control of the claimant's property and making it vulnerable. That's an entirely different situation. That doesn't breach any of the rationales why there's no liability for emissions.
You would say that that's a Stansby and Troman situation,
Exactly.
despite the fact that there's no contract.
Yes. Well, I'll come to Stansby when I'm looking at the special relationship exception.
When you do, can I just mention one thing? On seeing these papers, the word Dove and Bannums immediately occurred. It's not in the bundles, but as far as I'm aware, Dove and Bannums has never been doubted. I tried to do a search. Although the main issue in Dove and Bannums was limitation and whether Pirelli applied, so far as I'm aware, no one has ever said, and Mr. Justice Hodgson got it wrong on the primary question of whether there could be liability. But if I'm wrong about that, I'd be grateful to be put right.
My lunch is getting busier by the moment.
Well, Mr. Brown's got enthusiasm.
Yes, indeed. Good, so that's Stoven and Wise. Could I then take you, please, to the Mitchell case, which is behind tab 8 in the first authorities bundle. Sorry, I've said tab 8, I mean tab 7, sorry.
Do you? I think Mitchell is at tab 8. Mitchell and Glasgow City
there it is.
Council.
Oh, good. Sorry, tab 8, Mitchell. Yes, thank you. 172. And this was another claim against a local authority. And it was brought by the widow of a local authority tenant who was killed by another of the local authority's tenants. And the question is whether or not the local authority owed a duty of care in relation arising out of that other man's conduct, and the claim was dismissed on the basis that no duty of care was owed. But I wanted to take you to initially a passage in the speech of Lord Scott, paragraph 39, please, which is on page 191 of the bundle, paragraph 39 at 191. And he starts paragraph 39 saying it's a feature of the common law of both England and Wales and of Scotland that liability and negligence is not imposed what is sometimes described as a mere omission. And further down that paragraph, 5 lines up from the bottom, he says the legal duty to take positive steps to prevent harm or injury to another requires the presence of some feature additional to reasonable foreseeability, that a failure to do so is likely to result in the person in question suffering harm or injury. The fallacy, both in England and Wales and in Scotland, would have been a breach of no more than the moral obligation. And he then goes on to address what that additional feature might be. The requisite additional feature that transforms what would otherwise be a mere omission, a breach of at most a moral obligation, into a breach of legal duty to take reasonable steps to safeguard, or to try to safeguard the person in question from harm or injury, may take a wide variety of forms. Sometimes the additional feature may be found in the manner in which the victim came to be at risk of harm or injury. If a defendant has played some causative part in the train of events that have led to the risk of injury, a duty to take reasonable steps to avert or lessen the risk may arise. Because where the defendant's played some causative part, he's not the bystander doing nothing. Instead, he's someone who's engaged in a relevant activity, like Mr. Jeffrey, who did play some causative part in the train of events. Clear causative train between him going up to a secure building, rendering it insecure, and as a result of that insecurity, someone's able to enter the building who causes substantial damage by fire.
Well, on your submission, that's the making it worse.
Yes. Yes. But
If you succeed on your first round, so that this is a case of making things worse. You could still be met by an argument at trial that the act of the vagrant
Broke the chain of causation. Yes, causation's for another day.
But the question for today is simply arguable.
Yes. Is it arguable a duty was owed? And we park the issues of breach of duty.
Yeah.
He'll no doubt say, well, I didn't have to lock the door because it would have been unsafe to lock me inside the building.
Yeah.
If that's right, there's a duty, but there's no breach of it.
Yeah.
They may say, well, the acts of the vagrant were you know.
I'm always slightly reticent about using the word very, but you'd say on arguability that the act of the vagrant is the very thing that they were meant to be guarding against.
Precisely.
Yeah.
Precisely. And we'll see that picked up in
was the very risk that you were under a duty not to make happen.
And that's why it's said against us, well, the purpose of these locks is to lock people in the building. Well, no, it's not. The purpose of these locks is to lock people out of the building to protect against the very risk that arose, people getting in and causing damage.
And I understand why you're using it, but actually to say it made things worse is not quite accurate in this case. You would say it's the difference between a secure building and a building that has been rendered insecure. So it's not making things worse, it's creating a situation which allows for the risk.
Yes, I mean, depending on how
how
broad a meaning you give to the word worst. I mean, certainly, if someone rang up the claimant and said, you know, are you in a worse position generally now because your building's vulnerable? You'd say, yes, I am in a worse position. So that's Lord Scott. And sorry, I was saying in answer to my Lord Justice Coulson that there are, unfortunately, I can't take you to one case which sets out the whole law on all of this. And one has...
That's what we're here for, Mr. Elkington.
I was going to say, perhaps this is it.
And so I'm taking you to a number of cases which all approach the same problem in slightly different ways. And then if I could take you to paragraphs 57 and 58, please. Um, 57 is at the bottom of internal numbering 196, where Lord Rogers says, as Lord Gough explained, and that was in Smithson Littlewoods, in some circumstances a defender who provides an opportunity for a third party to harm the pursuer in a foreseeable way must take reasonable care to prevent the harm. And I emphasise the words provides an opportunity because that was the very reason that the judge said this case failed, because all Mr. Jeffrey did was to provide an opportunity for the vagrant to enter and start a fire, and providing an opportunity is sufficient. So he says, a defender who provides an opportunity must take reasonable care to prevent the harm. If I negligently collide with a cyclist who's knocked unconscious, I must surely take reasonable care to move her from the path of oncoming vehicles. Whether I must also take reasonable care to prevent her belongings from being stolen may be more debatable. Similarly, a decorator who leaves the door of an empty house unlocked is indeed liable if a thief then enters and steals, because the main point, at least, of the decorator's duty to lock premises is to prevent theft. That Stansby and Troman. And we'll come back to that in the context of the other exception. But it's relevant here because, I mean, whenever you're looking at these cases of is there liability for the conduct of a third party, it's the third party's conduct that is the immediate cause of the loss, the person who started the fire or whatever it might be. But that doesn't mean there's no liability. If the defendant has created the opportunity for that, then there can be liability.
You're better off calling it created the risk.
Created the risk. Thank you.
Well, I mean, when I say you're better off, I think it's more accurate.
Yes. So that's all I need to take you to in relation to Mitchell. Could I then, again, just taking it in chronological order as the cases have developed, take you to Robinson, which gets us into the second authorities bundle. At tab 11. in Robinson, the claimant was an old lady who was injured in a shopping centre when the police were arresting a suspect. And the question was whether or not the claimant was owed a duty of care, and the Supreme Court held that she was owed a duty of care by the police. And Lord Reed gave the lead judgment, and Baroness Hale and Lord Hodge agreed with him. And I wanted to take you, please, to what he said at paragraph 69.4, which is on page 370 of the internal numbering of the bundle. And you wouldn't know it's 69.4, there's no 69 written on this page, but it's 69 subparagraph 4 that starts at the upper hole punch of page 370. And could I invite you to read that whole of subparagraph 4, please?
Thank you. Thank you.
So that's a further helpful discussion of the rule, and identifying in the last sentence 3 exceptions to the rule. And what we're looking at this point is the last third of those exceptions she identifies, situations where the omission arises in the context of the defendant having acted so as to create or increase a risk of harm. It's slightly two sides of the same coin, because some might say, well, if you've acted so as to create or increase a risk of harm, it's not an omission at all, because you've done something. And it maybe it's really a sort of temporal question, depending on how big a gap in time there is between you creating or increasing the risk of harm.
It might matter if what you originally did wasn't negligent.
Yes, indeed. And we've seen, I think, the reference to, for example, if you put out a drug non-negligently, but then subsequently discover, perhaps a thalidomide drug, that it is dangerous, of course you're under a duty at that point you've created a risk of harm, and you've got to tell everyone, mother, stop taking that drug. And then the other passage...
So as you say, it is slightly counterintuitive, because if it's talking about omissions, and then it's talking about having acted so as to create, is that an exception to pure omissions, or is it actually a different way of putting the duty?
Yes. Well, I think when as we'll see how the laws develop, particularly in Begum, when one says the proper distinction shouldn't be between acts and omissions, it should be between making things worse or conferring a benefit. If you've acted to create an increase or risk of harm, that's making things worse, and so it should fall into the it's not an omissions pot. But the law's developed, and it's not always entirely easy to see whether or not someone's saying it's not an omission at all, or it is an omission but there's an exception, because you've created a risk. And end of paragraph 70, if I could just take you to that again. I think perhaps if I can invite you to read paragraph 70 just over the page.
And
that
you are,
fit-
sorry.
And that fits with one of Lord Reed's other purposes in this judgment, which was to explain where the confusion had arisen about immunity.
Yes, yes. It was said
It's
the
just
police
the,
have a
it's the
blanket
wrong,
immunity.
effectively, it's the wrong term. You should be asking, is there a duty?
Yes. And so he says the police are under the ordinary principles of the law of negligence, and applying those principles, i.e. the ordinary principles of the law of negligence, the police may be under a duty of care to protect an individual from a danger of injury which they have themselves created. Now that was because we're looking at a personal injury case, but applying that to this case, the defendant would be under a duty to protect the claimant from a danger of property damage which the defendant itself created. And it created the danger of property damage because, and including a danger of property damage resulting from human agency, because they rendered the building insecure, creating the risk of the danger or the risk of property damage, including by a third party.
I'm so sorry.
That's all I wanted to take the court to in Robinson, and then one more case before we get to Begum, which is the N and Poole Borough Council case behind tab 13. And this was another case against a local authority. It was a claim by children against the local authority, and their allegation was that the local authority had failed to protect them from harm caused by unpleasant neighbours. And the claim was dismissed on the basis that there was no duty owed. Lord Reed again gave the lead judgment, and all the other members of the court agreed with him. And we've got both the Court of Appeal decision and the Supreme Court decision in the bundle. And so I want to take you to Lord Reed's speech on page 448 of the bundle, please. And it's paragraph 28. And as we'll see in a moment, this was a paragraph that my Lord Justice Coulson referred back to in the Begum case. Thank you. So he identifies that it's preferable to draw the distinctions not between acts and omissions, but between making things worse and failing to confer a benefit. Someone wandering along the street has a duty not to make things worse, doesn't have a duty to go out of his way to confer a benefit on someone. And in the last sentence, he identifies that the duty to protect from harm or confer benefit might arise in particular circumstances. For example, the public authority had created the source of danger or to assume responsibility to protect the claim from harm. And it's again the creation of the source of danger, which is relevant at this point in my submissions. That's what Mr. Jeffrey did. He created a risk of danger to my client's property. That then brings me to the Begum decision, which is behind tab 15. I'm afraid we don't yet have it, it's not yet reported, so we have the full printout without any headnote behind tab 15. And no doubt I'll be told I've got this all hopelessly wrong by Lord Justice Coulson, but it was a claim by a widow of a man who worked in a shipyard in Bangladesh, breaking up ships, and he was killed while he was breaking up a vessel. And a claim was brought by his widow against the company which had arranged for the sale of that vessel, which it knew would be broken up in Bangladesh. And it was an application to strike out the claim, and Mr. Justice Jay refused to strike it out, and the Court of Appeal also refused to strike it out. And that was notwithstanding there being no relationship between the defendant who had arranged for the sale of the vessel and the injured person, or indeed any relationship between the defendant and the shipyard, and the defendant having no involvement in the operation of the shipyard, and the deceased having no connection with or knowledge of the defendant. And Lord Justice Coulson gave the lead judgment, and Lord Justices Mayles and Bean agreed with him. I just wanted to take you to 3 or 4 paragraphs of his judgment, please. Beginning with paragraph 60 on page 521. Which begins that same paragraph in Lord Reed's judgment. That's paragraph 28, which I've just taken you to. And if I could invite you to read paragraph 60 and 61, please.
Yes.
And in paragraph 62, he then identifies that the claimant's second way of putting its case was based on the proposition that it wasn't a case where the defendant had failed to make things better, he had made things worse. And then in paragraph 64, he says, whilst I do not underestimate the hurdles that Mr. Hermer's route to face at trial, I consider that this way of putting the claim is arguable and not fanciful. Creation of danger is a recognised exception to the usual rule as the intervention of third parties which may give rise to a duty of care. And then I can take you to Lord Justice Mayles' judgment, paragraph 124, which is on page 533. And Lord Justice Bean agreed with this. Says at 124, as Lord Justice Coulson has explained, there's a well-established exception to the principle that the defendant is not liable for harm caused by the acts of a third party, which applies when the defendant is responsible for creating a state of danger, which results in the third party causing injury to the claimant. My judgment is at least arguable that this exception applies here, or at any rate its application will present only a minor incremental step from the existing authorities to which Lord Justice Coulson has referred. I'm asked to draw your attention to the balance of that paragraph. So in the light of that review of the authorities, in my submission, the judge ought to have considered 2 things at this stage of her analysis. First, was the defendant someone who was doing nothing in particular, or was Mr. Jeffrey engaged in a relevant activity? Is a passerby or someone who's engaged in an activity? And secondly, whether Mr. Jeffrey created a danger of damage to the claimant's property, including a danger of damage resulting from human agency. So then if I can just take you how the judge did deal with this, she didn't ask those questions, and she approached it in a different way. And her judgment is behind tab 12. You may have taken that, put it somewhere else, but it's in the appeal bundle behind tab 12. And the relevant paragraph is at paragraph 39. I can just invite you to read paragraph 39 and then make my submissions on where I say she's gone wrong. And there are a number of respects in which in our submission, the judge went awry in her reasoning there. The first is that the judge didn't analyse whether this was a case of the defendant failing to make things better or making things worse. Had she applied that test, she should have appreciated that this was a case of making things worse, because the defendant disabled the security of the claimant's property and left it insecure.
She didn't cite, and I don't know whether it was cited to her, the Poole case, where that is expressly the point of paragraph 28 of Lord Reed.
Yes, and it was before Begum was decided.
Yes, but I mean, in relation to that specific point, Begum simply repeats what Lord Reed said in Poole. So the more important thing is Lord Reed. I couldn't find a reference in her judgment to Poole. Was it an authority cited to her?
I'll
My lord, I can assist. It wasn't.
It wasn't.
No, it wasn't.
Right.
Miss Robinson.
My lord, yes, and there's extensive quotation from Robinson, Smith, Michael, Mitchell, all the other cases.
Paragraph 69.4 that we looked at of Lord Reed's speech in Robinson was in my
Yes.
junior skeleton.
Yes.
Which perhaps not as recited the same way as was subsequently done, but it makes a distinction between.
Yeah, I get the point.
So that's my first criticism. The second criticism is that the judge focused solely on the defendant's failure to lock the door. She refers in paragraph 39 3 times to leaving the door unlocked, failing to lock the door, failure to lock the door. She makes no mention of the defendant having disabled the alarm or leaving the door unlocked and unattended for about an hour, and the fact that there are those activities is obviously relevant in considering whether or not this was a pure omissions case. The third criticism is that the judge wrongly took the view that if Mr. Jeffrey provided the occasion for the third party to gain access to the building, then it was necessarily a pure omissions case. That's wrong. The judge should have found that the defendant created a risk of damage to the claimant's property, including damage caused by human agency such as a third party.
Could you just take us to where she deals with providing the occasion?
It's in the last 4 lines, the last full sentence. Sorry, the penultimate sentence of her paragraph 39. Mr. Jeffrey's failure to lock the door during his inspection inside the property may have been the occasion for the third party to gain access to the building, but it did not provide the means by which the third party could start a fire. It was not causative of the fire.
So she's gone straight to causation.
Yes, I mean, it reads like an economic loss case, this. It looks like Galoo, draw a distinction between causation and opportunity and so on, which is just not the appropriate analysis in a property damage case.
Well, providing the occasion is language which is used throughout tort when you're looking at causation.
Yes.
And does that stem from the first sentence of paragraph 39, where she's concentrating on the harm suffered was fire damage? And presumably, Mr. Appellant, you say, in any event, perhaps that's too specific?
Yes, and I'd also say that she's simply wrong to say that Mr. Jeffrey's conduct was not causative of the fire. If he hadn't left the door open and had operated the snib turn, intruders couldn't have got in to start a fire. It was a crucial step in the train of events which led to my client's property being burnt down.
And perhaps it is, as my lord says, because there perhaps is a concentration on causation.
Yes. And causation will be another battle for another day. This appeal's allowed.
You rely on the paragraph of the defence you took us to, 3.7a, which accepts that the property was at risk if not protected.
Yes. And it wasn't protected.
It wasn't.
Yes, and the judge said that Mr. Jeffrey's failure to lock the door didn't provide the means by which the third party could start a fire, but it did. It provided the means by which the third party could start the fire in the building. It may not have provided the matches, or whatever it was that was used, but if the building had been secure, the third party could not have started a fire within my client's building.
So if one looks at paragraph 39 as a whole and looks for the coherence of what the judge is wanting to say, I think what one could say is that although she uses the language of causation, she's using it to demonstrate that this was merely a failure to prevent harm being caused by others.
Yes, leading up to her conclusion that it's a pure omissions case.
That would make sense.
Yes. But firstly, it doesn't analyse properly what is a pure omissions case, insofar as it's still appropriate to use that language at all now the way the law's developed. And secondly, it doesn't grapple with the question of whether or not this is a creation of danger type of case, where the danger has been created by the defendant and exploited by the third party. Because the next two paragraphs, which I'll look at later, don't deal with that exception. They deal with the Stansby case, effectively, that exception.
But you would say that the faulty step in the logic is in the middle of 39, perhaps. If we're going 1, 2, 3, 4, 5 lines down, by leaving the door unlocked, the defendant increased the risk that an intruder might gain entry to the building. Locking the door would have prevented the third party from causing the damage. And then, failing to lock the door amounted to a failure to prevent harm. And it's that last conclusion, or the last sentence, that you would disagree with. You'd say the first two lead to making things worse.
Yes. And I'd also disagree with the third line, where she says the danger causing the damage was fire. That was too narrow a view of what the danger was. The danger was an insecure building in Leeds city centre that was vulnerable to surreptitious ingress by vagrants who might damage it. And it was in that dangerous condition because it was unlocked by Mr. Jeffrey and left unlocked while he went inside the building. Similarly, in the Begum case, the danger which caused personal injuries to the claimant were the working practices at the shipbreaking yard. But it was still held arguable that an exception applied, even though that danger was with nothing to do with what the defendant had done in that case. It was far removed.
I don't want to take you out of your course, but I think that's the point that you raised there, and you say you take issue with the sentence, the danger causing the damage was far, and you say that's too narrow. That I think is relevant to a point that I think is raised, that in some way the duty that you allege wouldn't cover fire damage, I think, as it's referred to. That in other words, I think it said, well, even if there was a duty, it would be a duty to prevent trespassers getting in, and that's different to fire damage. I think that's a point that arises, and so at some point you may need to address that, although in one sense you've addressed it in a sentence because you say that's too narrow. Your submission is that would be too narrow. Have I got that right?
Yes.
Too narrow an approach to type of damage.
Yes, I mean, yes, indeed. The danger is having a building that is insecure and vulnerable. It's vulnerable to the conduct of the activities of third parties, and that might be theft, vandalism, graffiti, or causing a fire. It could be any of those things. But all of those are things that you prevent by keeping the doors locked.
So it's happenstance, the precise type of damage caused.
Yes, I mean, it would be very
But if you've left the building insecure, on your case, if you've left the building insecure and somebody gets in, then there are various types of damage that are foreseeable, one of which is fire damage.
Yes, it would be very odd if there's a duty owed for graffiti, but not a duty owed for fire damage. Then I think
You see, I keep coming back to this. The leading case on that is Jolly, isn't it? The boat that fell on someone. But Mr. Brown's got a busy lunch, but I'll have a look at over lunchtime. But rather than just simply saying it's too narrow, there is authority, extensive authority, about whether you have to foresee the precise manner in which damage is caused, or whether it's sufficient that you should foresee physical damage or whatever it may be, injury.
I think
and it occurs in a slightly different way.
It's about week 2 of the law of torts, isn't it? Is it McNaughton, the person who falls in the explosion in the manhole cover in the pavement?
Well, I'm not going to admit that I turned up for the lecture on week 2 of the law of torts, but you may be right. But yes, it certainly stems from that.
Yes, I mean, I confess I hadn't understood it to be asserted that if there's a duty, the duty doesn't extend to damage by fire.
Well, we'll see how Miss Sinclair puts it, but I thought that as a result of the road map, that's a point that, depending on which road map you look at, is high up the batting order of points to be considered. Whether effectively it's a duty to prevent the type of harm that is then said to have arisen.
Yes. Well, I mean, I entirely accept that the duty in this case does need to extend to harm caused by a third party. We accept that the fire was caused by a third party. That was the immediate cause, third party. That was the foreseeable risk against which there was a duty to protect, because that was a risk that was a danger that was exploited by the third party. before leaving this and moving on to the other section of my appeal,
Hughes and Lord Advocate.
week 2 was some time ago. Could I just say the last criticism is in the 4 lines up from the bottom. She says the examples given by Lord Gough and Smith above are apt in this case. And that refers back to paragraph 30, where Lord Gough is in the Smith and Littlewoods case, which we'll look at in a moment. But he was dealing there with the situation of whether or not one property owner owes a duty of care to its neighbour for damage that neighbour suffers by reason of the conduct of third party on the defendant's land. In other words, if a building next to the Majestic had been damaged and that the owner of that neighbouring building had sued my clients saying you're liable because you allowed people onto your property. So it's a very different situation because it's criticising a defendant for the way the defendant has used the defendant's own property. In general party autonomy, we're all allowed to use our property as we want. Very different to this case where the claimant is criticising the way the defendant has used the claimant's own property. If you use someone else's property, you should take care of it. And the judge didn't have that distinction in mind when she said that the examples given by Lord Gough are apposite. Are apt, rather. Because those examples were all about, as I say, whether or not a property owner is liable for what third parties do on that property owner's own property. The judge wasn't considering whether or not my client would have had a liability to a neighbour, considering whether or not my client has a claim against someone who had caused their property to be insecure and susceptible to vandalism and arson. So that was unless there's anything else on that's as it were, my combined submissions on is this an emissions case at all, and if it is, does the creation of danger exception apply? Because as we've seen, those are slightly two sides of the same coin, or at least interrelated issues. I now want to come to a different exception, which is the one I identified as subparagraph A, which arises out of the Stansby and Troman case. And the exception applies where the relationship between the parties is such that there's proximity between them, so that even though it is certainly a pure emissions case, there's still liability on the defendant for damage caused by a third party.
And what's your heading? Is this assumption of responsibility?
Well, it's often referred to as assumption of responsibility, but I would prefer to call it imposition of responsibility, because what a number of the cases say is, well, although it's often referred to as assumption of responsibility, it's actually imposition of responsibility, because whether or not the defendant thinks he's assuming responsibility is actually the court imposing responsibility on him arising out of the relationship between the parties and what that defendant is doing. And
Well, okay. There is a different way of looking at it, which is leave aside contract. That it's absolutely on all fours because the relationship between the decorator, that's Mr. Jeffries, and the householder, that's the claimant, imposed a duty upon the former to take reasonable care with regard to the state of the premises if he left them during the performance of his work. You would now finish that sentence, the duty of care being not to create the risk of. So you come back to your previous analysis.
yes. Well, my lord, I did toy with just going straight to Stansby and Smith and Littlewoods and say, look, there it is. At the very least, it's arguable. But, you know, I felt that would slightly get my whole submissions upside down, and I needed to start with the headline, is this an emissions at all? Because if it's not, you don't need to get to this exception. So it felt a bit upside down to start with an exception and then go to the primary rule from which the exception is an exception. But certainly that would be my submission. Just look at Stansby, look at how that's been approved in Smith and Littlewoods and developed, and where it's expressly said it doesn't matter if there's a contract. So that's not the basis of Smith and Stansby.
Expressly said it may not matter.
Well, I may be overstating that, for which I apologise. But let's turn to Smith and Stansby, if we might. It's the first authority in the authorities bundle in the days when authorities were blissfully short.
And had head notes.
And could I invite you to read the head note on and you'll see there's no reference there to the householder giving any instructions to the decorator that he should lock the door if he goes out. One of the points that's taken against me is that Mr. Jeffrey was never instructed to lock the door, but that doesn't matter if something's a matter of common sense, and also if you've got a history of dealings with a property where other people have locked it, indeed asked you to lock it. But I think the only passage I need to invite you to read is on the bottom of page. Lord Justice Tucker gave the main judgment, and if we can go over to page 51, please. At the bottom paragraph, where he grapples with the argument that's being advanced that, well, you can't impose liability on the decorator for loss caused by a third party who came and committed the theft. So the Court of Appeal rejected the argument which found favour with the judge in this case, that the distinction between providing an opportunity and providing a cause. Now, you can argue about whether that should fall within the duties section or the causation section or somewhere else, but it clearly was something that the judge thought was relevant to the only issue she was deciding, was there a duty? And the way she approached it was inconsistent with the way that the Court of Appeal said it should be approached when looking at Stansby. And then the last authority I want you to take you to, if I might please, is the Smith and Littlewoods case, which is behind tab 3. And the issue here that the House of Lords were considering was whether or not an occupier of one property owed a duty of care to the owners of neighbouring properties when trespassers got onto the defendant's property and started a fire which caused damage to those neighbouring properties. So the plaintiffs were trying to fix the defendant with liability arising out of the way in which the defendant had used the defendant's own property. So, as I've made the point already, different to this case where we complain about the way the defendant used the claimant's property. But the reason I take you to it, notwithstanding that difference, is because there is consideration of the Stansby case by both Lords Mackay and Lord Gough, who gave the leading speeches. And if I could take you first of all to Lord Mackay's speech on page 51 internal of the bundle, page 51. And could I invite you to read the sidelined passage at the bottom of 51 and down to 52C.
So you rely on the sentence that starts, I think it could be said that.
I do rely on that. I also rely on the sentence at the top of the page. I should have thought that on the same facts, a guest of the plaintiff who'd left the property in the house if it had been stolen might also have succeeded in recovering damages with respect to that theft, the decorator. And that's relevant because, of course, the guest of the plaintiff wouldn't have been in a contractual relationship with the decorator. But Lord Mackay is still saying that notwithstanding the absence of contractual relationship, there would have been a claim in negligence, given the defendant's status as a visitor in the property. And that's, of course, significant to when one looks at the way the judge dealt with Stansby, which was really to say there was a contractual relationship, so we can forget about that because there wasn't a contractual relationship in this case. But yes, my lord, I also rely on the section that you've identified, which is entirely on all fours with this case. The whole purpose of locking the doors to keep intruders out. That's what Lord Mackay had to say. Then could I take you to some passages of what Lord Gough said. To 271B, that's 271 of the report, he makes the point, why does the law not recognise a general duty of care to prevent others from suffering loss or damage caused by deliberate wrongdoing of third parties? The fundamental reason is that the common law does not impose liability for what are called pure omissions. And that's the context in which he sets out what he says at over the page 272D. I can invite you to read the sideline passage at D and E.
How far do you want us to go?
Just to the bottom of E, where he says such responsibility might well be held to exist in other cases where there is no contract. As for example, where a person left alone in a house has entered as a licensee of the occupier. And that, of course, is precisely this case. Mr. Jeffrey was a licensee of my clients in the building. He was alone so far as my clients are concerned, in the sense that they weren't there with him, albeit he had two other people with him. And I also emphasise what's said in the third line, where the duty may arise from a relationship between the parties which gives rise to an imposition or assumption of responsibility. So where you've got a contractual relationship, you might say, well, that's an assumption of responsibility. But even where you don't have a contract, the relationship between the parties may be such as to give rise to an imposition of a liability, and one such situation being where you're a licensee in someone else's house. And then the last section I'd like to take you to, please.
Oh, but just so that you know, I have anyway highlighted the last two lines on page 272 going over to the first two lines of the next page, which seem to me to be relevant.
Well, I certainly thought they were relevant when I was doing the sidelining as well. But I'm conscious of the time.
I'm sorry, I interrupted you.
No, he's dealing with the creation of a source of danger. I mean, what he was more specifically looking at there is the classic example of the man who keeps fireworks in his garden shed. And where he does that and someone sets those off, he might have a duty to his neighbour whose property is damaged by those fireworks exploding, because he's created a source of danger on his own property. That's slightly different factual situation here. I mean, if my client had stored dynamite on its property and the vagrant had set those off, and so the neighbouring properties had all been flattened, my client might be sued by the owners of those neighbouring properties. But that I think is the or one of the origins, at least, of the source of danger exception. Albeit in that case it's dealing with a slightly different factual situation. Right, so last passage, 279D, if I might please. Could I invite you to read the whole of the sideline paragraph starting at 279D? So it's an observation that in the Stansby case, it can't have been at all likely that the thief would take advantage of the fact that the door was left on the latch while he was out. But that didn't mean that no duty of care was owed or the claim was otherwise one that would fail. But of course, in this case, it's admitted that if the door was left unlocked, the property was at risk of entry and damage by intruders, and that risk was foreseeable. So could I then just, I'd take you to the judgment where the judge dealt with the applicability of this exception, which is back in the judgment behind tab 12, paragraphs 40 and 41. probably just leave you to read those two paragraphs yourselves. And begin to summarise my criticisms of those paragraphs. The judge was wrong to say that none of the legally significant features of the early authorities exist in this case. It was the legally significant feature of Stansby was that there was someone carrying out works in the claimant's property and then left that property unlocked for a period. And that gave rise to a liability. The liability arising out of the fact that he was a licensee in the property and owed a duty to take care to ensure that property was protected from the conduct of third parties. And Smith and Littlewoods strongly indicate that the existence of a contract in that case was not the key feature. The key feature was the fact that the decorator was in the claimant's property. Secondly, the judge says there were no dealings between the parties and no exchanges between the parties which crossed the line. That's surprising because there were obvious dealings between the parties. The defendant had entered the claimant's property a number of times. He had asked if it could enter another time. The fact that it asked the claimant's agent rather than the claimant directly doesn't make a difference. It was given permission to enter the claimant's property. It was provided with a key to the property. It was provided with the alarm code for the property on behalf by agents acting on behalf of the claimant. And it then entered the claimant's property as a licensee. So those are obvious dealings between the parties. This is not a case of someone walking down the street and seeing the door was open and not shutting it, or not raising the alarm when it saw a vagrant going inside. There would be no dealings between the parties, but this wasn't someone, a bystander walking down the street. This was someone who had asked for permission to go into the property and been granted that permission. And the defendant, in legal terms, was a licensee, and as you've seen, Lord Gough identified a licensee as one of the particular relationships where a defendant might be responsible for the acts of third parties. And Lord Mackay also didn't think the existence of a contract was crucial. Then in paragraph 41, the judge thought it relevant that the defendant wasn't a fire or security expert. But I mean, the decorator in Stansby wasn't a security expert, he was a decorator. You don't need to be an expert to understand the importance of locking a door. Just about everyone in the country will lock the door when they go out. But the defendant was, of course, a professional, an architect. And then the judge says, well, the absence of dealings preclude any finding of reliance. I don't accept that reliance has any relevance in the analysis at all. But even if it did, there were dealings between the parties. And the judge omitted any reference to the claimant's pleaded case that it was aware of Mr. Jeffrey's visit and relied upon him to take precautions by either locking the door or monitoring the door, so that the risk of people entering the property surreptitiously, which was foreseeable as the defendant accepts, didn't happen.
Or to put it another way, relying on him to keep the place secure.
Yes. Good. And the final point I wanted to just touch on was the issue of, sort of reciprocity. Is there any unfairness in a finding that the defendant owed the claimant a duty? In my submission, no, because the claimant owed the defendant a duty. As the occupier of premises, the defendant owes a duty to visitors. And that exposed the claimant to a liability to the defendant. And that duty extends to liability for injury or damage caused by a third party. And that we see that from one of the cases that the defendant relies on, which is Pearl and Camden, in the authority bundle at tab 2, and I'll just refer to it briefly because it...
Sorry, which bit of the judgment does this go to?
Well, it doesn't. This is a more general point of, is it, and you may say it's totally irrelevant, but is it unfair to find that A owes B a duty in circumstances where B owes A a duty, both owing a duty to prevent harm to the other by third parties? And I just happen to notice in the sidelining the defendant has put on the Pearl and Camden case that Lord Justice Gough, as he was then, said, well, an occupier may be liable under the Occupiers Liability Act, not only for what they've done, but also for what third parties do on their premises. And it would create a great asymmetry if my client could be liable to the defendant for things that third parties do, but the defendant's got no liability at all in this case. If that's unhelpful, I won't take you to the sections, but I just wanted to give you a couple of brief references.
Well, it only arises if we're outside the presently established
Yes.
categories of cases.
Well, I'm happy to leave it there. Good. Well, I hope that's appropriate timing. As you know, I don't have to persuade you that there is a duty. I've just got to persuade you it's arguable as a duty. My client's case isn't fanciful, and in my submission it's not.
Thank you very much indeed. Miss Sinclair.
Thank you, my lady, my lords. This is an unusual appeal because it's not an appeal where I can structure my submissions as one would in the usual way by reference to the grounds of appeal. Because as my Lord Justice Coulson observed when he granted permission, they are unfocused and unhelpful. I also face the difficulty that in seeking to deduce the appellant's putative grounds of appeal from the skeleton argument, we have two skeleton arguments with different authors. They're not always consistent. So the grounds of appeal are somewhat shifting in this case. Nonetheless, I shall do my best to cover all of those which might have any attraction for you. What I propose to do is follow my Lord Justice Coulson's direction in granting permission to focus on the two principal questions. Was the learned judge in charge of the Technology and Construction Court right to decide that this was an emissions case? And if she was right, was she also right to decide that it is not a case where there operates a recognised exception to the rule that there's no liability in tort for an emission? And it's clear from the learned friend's submissions that there are two exceptions in play: the creation of danger exception and the assumption of responsibility exception. So I propose to follow, subject to you, much the same course as my learned friend. A word first about the facts, then the emissions principle, or the not making things better principle, as we now call it after Poole. Then exception 1, creation of the danger, and exception 2, assumption of responsibility. So first, the assumed facts. I make 3 preliminary points about the facts. First of all, they are narrow in compass, and they are largely common ground. only one significant fact needs to be assumed for the purposes of this appeal, which relates, of course, to a summary disposal of the case. And that is that the fire damage was caused by a trespasser who entered during Mr. Jeffrey's morning visit, using the door which Mr. Jeffrey used, and then that trespasser remained in the building without triggering the alarm sensors, which were, as my learned friend says, throughout the building, for many hours before starting a fire in the evening. It is common ground on the pleadings that it was one Mr. Jefferson who started the fire, not least because he admitted doing so in criminal proceedings. He says he entered at a different time and by a different door, but we must assume, for present purposes, that he entered by the door that Mr. Jeffrey used and during his visit. And the third preliminary point is that the appellant does not suggest, and it is not the case, that there is any relevant dispute of fact which bears on the question of duty of care in this case. That there is not and has never been any suggestion that a trial would be justified on that basis. So, turning to the facts themselves, it's common ground that this was a large and complex building. My learned friend helpfully took you to the floor plans. Those are the as-built plans after the claimant's works. And we set out in the defence what you could see from those plans if you looked at them perhaps a little longer than you're invited to do. First of all, there are many doors at ground floor level. There are 17 of them. 11 of them open directly onto the street. 5 of them were on the same elevation. Of those 11, 5 were on the same elevation as the door which Mr. Jeffrey used. It is also common ground that inside the building was poorly lit and it was dark in places. And although not directly relevant today, you will have seen the pleaded defence. Mr. Jeffrey's explanation for his behaviour was that it would have been unsafe on his assessment to, in any way, bar his escape route from a building of this sort. So far as his visit are concerned, again, the facts are common ground, and the learned judge set them out at paragraph 19 in the judgment. That's page 122 in the building. But there is one appropriate correction. The learned judge recited common ground, no direct dealings. Claimant entrusted the keys to the property to letting agents. In fact, there were 2 firms, not that that matters. The letting agents gave the keys to Mr. Jeffrey. The defendant firm didn't accompany him, didn't instruct him that the door should be locked or monitored during his visit. During his visit, the side door was unlocked and the alarm system was deactivated. And when he left the building, he locked up again and reactivated the alarm. The correction I mentioned is the reference to the keys to the property. That's not the case that is pleaded. The case that is pleaded is that Mr. Jeffrey was given 1 key to 1 door. Given that there were 17 doors at ground floor level, it would be very surprising if this were the only key to this property.
Are you setting yourself up for the trial, or is that material to the present issue?
It is material, my lord, because one of the questions is whether Mr. Jeffrey created a source of danger, whether he had control or assumed responsibility for control over the security of the property. And I would invite you to bear in mind the reality of the case. This holding a single key, it's a leap from there to say that he was responsible for the security of the entire building. I'll come on to that in due course if I may.
But isn't that precisely the sort of thing that would be coming out at trial? I mean, this is happening more and more. People say, well, we don't have to worry about the trial because all the facts are agreed. And then we get submissions at the nuances that we're supposed to draw from the facts. And I say bluntly, the law of tort is being distorted by there being too many interlocutory cases about duties of care, rather than cases where duties of care are the subject of trials. And so, I mean, Beacom is a good example of that in one sense, because the only issue there was whether it was arguable. As for us here, that is the issue. But I do have a concern that we're regularly told, well, the facts don't matter, but then nuances potentially we are asked to draw, which may be relevant to the underlying question.
My lord, all I invite you to do is bear in mind, if I may, that the case must be decided at summary stage on the pleaded facts.
But I'm afraid my lord's reference to nuance, your nuance is too subtle for me. Because if you've got a secure building, does it really matter whether you're given one key or a whole bunch?
Well, but perhaps the other way of putting it is this: it is not alleged anywhere in the particulars of claim or the reply that Mr. Jeffrey was aware of certain key factors which my learned friend has assumed. First of all, it's not alleged that he was aware that this one key to this one door was the determining factor in the security of the entire building.
Well, that's unreal. Surely, Miss Sinclair, that's completely unreal. I mean, you've got an enormous building in a highly visible place in a city centre, and he goes and is given the key to get into the building. What other assumption does one make? That all the other 16 doors are open?
Well, I accept it's pleaded all the lockable doors were locked, but that doesn't exclude other possibilities, such as that there was a defect. You will have seen the plan at page 45, and you will have noticed...
You're setting yourself up for trial. This case is being presented to us on the basis that it was a secure building and that the security was compromised by his leaving the door open or unlocked.
But my lord, if I may, the step that jumps over is that Mr. Jeffrey ought to have appreciated as much.
Well, maybe you'll get a finding at trial that he wasn't negligent.
But it's not even alleged that he ought to have appreciated that. And that is my point. If this were a terraced house, a small terraced house, then being given the front door key, I would accept, would be being given all you need, more or less, for security. We'll leave the rear of the building on one side. But being given one key in this case, when it's not alleged he realised that this was the only means of access to the building.
Okay.
But are you saying also that there were multiple alarm systems? He was given the code for the alarm. Presumably you accept that by disarming the alarm and leaving a door unlocked, he was leaving the building insecure, and I think that is accepted in the defence. So I don't understand where all this goes, really.
My lady, we accept he disarmed the alarm.
And you're not saying there was more than one alarm?
I'm not saying there was more than one alarm.
Fine, so whether it's one key or one door, what difference does it make?
The difference in my submission is this, that in order to find that he owed a duty of care which embraced the security of the building. In my submission, the claimant would need to have alleged that he understood that holding the key in his hand meant that he held the entire security of the building in his hand.
And my point was, if you accept there's only one alarm and he enabled the alarm, then is that not just as a matter of common sense the answer? However many keys you've got.
Well, I take your ladyship's point. I won't pursue that further.
But in any event, I also endorse everything that my my learned colleagues have said about this strand of argument.
Also, at the moment, I'm not convinced the point's even open to you, where it is pleaded in paragraph 7 of the points of claim that the risk of such intrusion and damage in the event of the property not being kept properly protected as above was reasonably foreseeable to Mr. Jeffrey. That's a meaningless averment unless it carries with it the foreseeability that the building is dependent upon him for its security.
My lord, we have accepted in the defence that by leaving a door unlocked with the alarm system off, that there was an increase. Obviously, it's self-evident.
Okay. Well, I regret to say that at the moment I don't understand the force of the point.
Well, my lord, then I'll leave it and come back. It's not a central point in my submissions. Thirdly, the fire damage. We must assume that it was caused by Mr. Jefferson. In the circumstances I've indicated, it is common ground, of course, that Mr. Jefferson, the third party, was not a person under Mr. Jeffrey's control. Well, that's all I propose to say about the facts. I'll come on now, if I may, to the omissions principle, or the not making things better principle. In our supplementary skeleton, we reminded you of two decisions of the Supreme Court since this appeal was lodged, which, by contrast with the appellant, we say are very important. They identify the correct approach to be taken when considering any claim for damages or negligence. They are Manchester Building Society and Grant Thornton and Carnham Meadows. And they were provided by the same panel of 7 members of the Supreme Court on the same day. The first was Meadows and Carn. I will take you to that briefly, if I may. And I take you to it for this principle, that the question of the scope of a duty of care cannot be separated from the question whether a duty of care exists at all. In Meadows and Carn, the judgment of the majority was given by Lords Hodge and Lord Sale. And the first passage I'd invite you to look at is on page 615 in the Bible. Paragraph 28. And there are there set out the 6-step analysis which the Supreme Court proposes in cases where negligence is concerned. The first one is actionability. Is there an actionable kind of damage? That doesn't arise here. But the next one is, what are the risks of harm to the claimant against which the law imposes on the defendant a duty to take care? And that is identified as the scope of duty question.
Forgive me, Miss Sinclair, I didn't get the page number you were
I'm
on.
so sorry, my lord. It's 615.
Thank you.
So question number 2 is scope of duty. Question number 3 is breach. So we've moved straight on from, is the kind of harm an actionable damage? You know, is it damages for pure mental distress, which which are not recoverable, or is it something such as physical damage, which is? Straight on to scope of duty and then to breach. There is no separate question about existence, and the reason is that...
No separate question about...
I'm so sorry, my lord.
What did you say? No separate
There
question?
is no separate question. Does the alleged duty of care exist as a matter of law? Was there an alleged, the duty of care as alleged in this case? And what we take from that is our submission that under the law as now clarified by the Supreme Court in these cases, the question of the existence of a duty of care and the question of the scope of the duty of care are effectively indistinguishable. And the reason is that the question of the existence of the duty of care must focus on the risk of harm which is complained of. And one sees why that is. If you would turn on, please, to paragraph 34 at the bottom of page 617. The Lordships mentioned Caparo and Lord Bridge and Caparo citing Justice Brennan's judgment in Sutherlandshire and Hayman. And what I would invite your particular attention to are the quotations on the following page, 618, A and C. Lord Bridge said, it's never sufficient to ask simply whether A owes B a duty of care. It's always necessary to determine the scope of duty by reference to the kind of damage from which A must take care to save B harmless. And then, just below B, in the same case, Lord Oliver of Elmerton said, has to be borne in mind that the duty of care is inseparable from the damage which the plaintiff claims to have suffered from its breach. It is not a duty of care to take care in the abstract, but a duty to avoid causing to the particular plaintiff damage of the particular kind which he has, in fact, sustained. And apologies for going backwards and forwards, but at paragraph 30 at the top of page 616, you see the analysis, the 6 questions, serves to demonstrate that the answers to the questions of factual causation and foreseeability on which Mr. Havers relies cannot circumvent the questions which must be asked in relation to the scope of the defendant's duty. And what the court is saying, quite simply in my submission, is that but for causation and foreseeability aren't sufficient, will never suffice to give rise to a duty of care. What one must focus upon is the particular harm suffered by the particular claimant and the defendant's relationship to that. Now, paragraph 37 on page 619, this analysis is linked explicitly to what was known as the Emissions principle. The scope of duty principle may also be of analytical value and of central importance in other circumstances, such as where a claimant seeks to establish liability arising from the defendant's omissions. One example is when the court is considering whether a defendant owed a duty to prevent injury or damage to the person or property of the claimant which has been caused by a third party, see for example Smith, Mitchell and Michael. It was in my submission the reason why the court in Meadows troubled to refer to the emissions cases, which didn't have anything to do with the facts in Meadows and Cunn. It was a professional advice case. The reason for that reference without any disapproval is that the intervention of a third party with independent volition raises starkly the question whether the particular harm suffered by the claimant, caused by the third party, was within the scope of a duty owed by the defendant. So what the court was saying, in effect, is that in cases such as Smith, Mitchell, Michael, and so on, the question of scope has already been worked out, in a sense, that the omissions principle, if I can keep calling it that purely because it's easier to say, the omissions principle and the exceptions to it are the established principles for working out the scope of the defendant's duty where the damage complained of has been caused by a third party. My lords, I mention this because there is criticism of the learned judge in this case for failing to appreciate that it was all very simple. Mr. Jeffrey played a part in the causal history which led to the fire damage. He allowed a trespasser access to the building. And on the appellant's case, that's all you need. My submission, it's not, because it ignores the fact that the courts have, over numerous authorities now, worked through these principles, and that what one is actually looking at, applying the principles to the facts of a given case, is whether the harm is within the scope of the duty. So, turning then to the cases where the court has considered the omissions principle.
Well, just on that point,
Yes.
is harm within the scope of the duty? What's your submission here?
Our submission is that the harm is not. The judge was right to find that the harm complained of here was fire damage, was property damage.
How caused?
Caused by a third party of independent volition.
So what? Sorry, I may have misheard your submission. Are you accepting that property damage is within the scope of a duty?
No,
of a duty?
no, my lord.
Your submission is simply that property damage caused by a third party is outside the scope of any duty that Mr. Jeffreys may have owed.
Indeed.
Okay.
And that if he owed any relevant duty, which we don't accept, but if he did, the very most it was to prevent access to the property by a third party. And as I'll come on to demonstrate on the authorities, it is well established that the mere grant of access to a third party is not enough to give rise to a duty of care, to give rise to liability for damage caused by that third party. And so the learned judge was quite right when she distinguished between the effects of what Mr. Jeffrey did, which admittedly, we have to assume, was to allow a trespasser onto the property, and what that trespasser of his own independent volition then did, which was
Right,
to
so if there was a duty, it was a duty to prevent access by the third party, but it didn't extend to what the third party did once it had access.
my lord puts
Once
it
he had access.
precisely, if I may.
So what's
And if
the-
I can add to that, that means that the duty is no duty at all, does it not? Because it's written water, prevent access by a third party, but it doesn't go as far as to
Doesn't matter
say,
what the third
doesn't
party
matter
does.
what the third party does. So, in fact, there is no duty in reality.
Well, my lady, that is our case. There is no relevant duty.
Well, there's no duty
In
at
this
all.
case.
So there's never a duty on your analysis. There's never a duty to prevent
a third party gaining access to someone else's property or to property, because there is no consequence, if you see what I mean. So therefore, how do you fit Stansby and Claimant into that?
Because I would not say there is never a duty. There is a duty if the defendant has specifically assumed responsibility to protect the claimant from damage to its property.
Or if they have created the risk.
Or if they have created the risk, but this is where, as my friend had to accept, and one sees it in the judge's reasoning as well, this is where the question whether we're talking about an omission or whether we are talking about positive conduct which creates a danger, there's an overlap. It's perfectly appropriate to look at it either way.
No.
But
You can't look at it either way. It's either one or the other, isn't it?
Well,
I mean, at the starting point, there is undoubtedly a difference between causing damage, which can be by creating a risk of damage. Causation arguments can come later. There's a difference between that and omitting to prevent damage for which you are not responsible, otherwise normally responsible. So at that point, it's a bifurcation. You're either talking about things which create a risk of danger, or risk of damage, or directly cause damage themselves, or a circumstance where you're under no obligation to do anything because you're not under an obligation to confer a benefit.
My lord, yes, I accept in theory it is right. It's either an omission case or it's not. If it's an omission case, but nonetheless you created the danger.
Well, you may get a judgment which, not today necessarily, but you, in a case like this, which says, I think there was a duty, I think there's using your language, a positive act. But if I'm wrong about that, it falls within one of the exceptions. But that's not eliding the two, that's just judicial backup.
My lord, yes, but what one does see is that if you decide that there is not an omission, so that there is a positive act, then creation of the source of danger is that positive act. So you've taken yourself outside the omissions principle again.
I think that's what I was trying to say, rather inelegant.
Not at all.
I think if this is an appropriate moment, Miss Sinclair.
It is, madam.
Thank you very much. 2 o'clock.
All right.